Yes.
From supplementary list, item number 1.
Yes.
I'm seeking your lordship's leave to appear
Who is for the
virtually in
respondent? Who is for the respondent? Have you served?
Your lordship, no, this is a private person. Notices have not been issued yet in the matter. The matter
But you have to serve,
concerns.
no? There's a section 5. Moreover, you have
Yes.
filed for a
So,
stay.
yes, your
So you
lordship.
have to file it. You have to serve it. Take down.
I'll serve it on the counsel who was representing before the learned single judge.
Very well.
Through the counsel.
Who is the counsel who appeared? Have you
Mr.
served upon the counsel who appeared?
No, your lordship. I will serve them. I do the need.
The application for condonation. Then keep it on Monday then. Their petition shall be.
Well, look here, the petitioner had applied for the post of the Gram Sevak, and he passed in the interview as well as in the.
This is not an appealable order. You wait. This matter is fixed on 5th December. It's not an appealable order. It's merely an order of takedown. Since it is not an. Yes. Yes, so you don't have a fundamental right.
My lord, exactly, my lord. The single bench has accepted our writ petition.
I think the direction is fine.
My lord, on the submission, my lord. Here, the next single bench directed the deputy commissioner to call for a meeting. Now, what happened? Meeting has been already called for. deliberation has been done.
Whether
Okay.
it will be, first of all, you don't have a fundamental right. It's not an infringement of a fundamental right settled up to the Supreme Court.
But my lord, that is one aspect of the matter.
So
Only
in
my-
the- so it is. It has. They have to follow the rules. If they are, if the community view is to be ascertained, that is why in paragraph 13,
But
His Lordship has given certain directions. With that, the petition was closed. What is wrong with this?
But here, my lord, my humble contention, with Lord's permission, if the competent authority, deputy commissioner and the village authority not yet decided the matter, my lord, the direction given by the single bench would matter, I really accept. Here, but the difficulty is that, my lord, the authority has already decided, government has given approval, on basis of approval, license has been issued, and my lord, the NOC has been given by the village authorities earlier. My lord. Now, only the subsequently complaint came forward and said that there is a local use in the village here. But it's a commercial area. It is a highway, my lord, just 3 kilometers from the High Court premises. It's in the national highway. So there is no, my lord.
That is dangerous. Drink and drive.
My lord, no, it is in the national highway. Only
National
statutory
highway,
requirement.
Drink and drive.
But statutory requirement is if there is a institution is there, like a religious worships, education institutions, hospitals are there. But these are the factors. Existence of the local youths is not the condition to deny the NOC. And village authority has taken into account that aspect. But just should invite Lordship attention to the NOC only.
No, that is why when your NOC was cancelled, you were not given an opportunity. That was your case.
Right.
So that is why these directions were passed.
But the state has filed affidavit. They say the NOC is not mandatory under the rules. However, ascertaining the local opinion is required. So they have ascertained it. But in my
Which for
lord,
the state? Which for the state?
my lord, can you see
What,
the affidavit?
what is your stand?
My lord, in our affidavit, my lord.
That is your trial court, single judge.
Yes, my lord.
My lord, see his affidavit, page number, my lord, 112, in the memo of appeal. My esteemed affidavit is colleague's affidavit is.
Paragraph 24.
No, section 28 has to be followed. Section 28 of the Meghalaya Excise Act has to be followed.
They
Correct?
have followed, my lord. Yes,
Section 20 is set out in paragraph 10 of the judgment.
yes, my lord. They have followed that. And after
The
following
opening,
that one,
shifting, amalgamation, closure shall be done by the district collector with the previous sanction. Such opening, unless it has been established by a local inquiry that is in the interest of public and until an objection which may have been filed.
para 24, page number.
Yes, so
100.
he has to. That is why when NOC was cancelled, That is why he has to follow the procedure under section 28. So in section 28, when the NOC is cancelled, so it has to be because at the time of when you open, when the license is granted, these normally it should be granted, it should be either open, shift, amalgamated, or closed. Unless it will normally be granted, unless it has been satisfactorily established by the local inquiry that the proposed action is necessary in the interest of public. So, if they close it, suppose it's a closure has to be on the basis of exercise of power under section 28. So, public interest element, they have to assess. They have not given you an opportunity. That is why His Lordship has set aside the order and granted and directed them that they must, in paragraph 13, that this procedure has to be followed.
But that is correct. My peculiar case is my license already has been issued of persons to NOC. Only my lord, one step further to take is that they need to issue a lifting order, lifting permits to me only, so that I can lift the goods and keep in my bar. Only that aspect, my lord, the complaint came forward. And only the sole ground taken by the local authorities, my lord. You kindly come to page number, my lord, 120. My lord may bear with me, page number 120. And that copy is page number 126. And the second paragraph is read out. We know that the presence of the bars will affect the youths within the locality and will attract many people and also strangers for consumption of alcohol within the locality. And the aftermath will be chaos and fights, and there will be no peace in the locality. And express our disregard against that. So the only ground taken by them is the youths. But in every locality, youths are there. If my business affects, there is a law that will take action against me.
See, few may have made a complaint, but the overall consideration would be of the collector. That is why closure, the power of closure is also there. Closure can be unless it has been satisfactorily established. Closure will not be there unless it has been established by local inquiry. The proposed action is necessary in the interest of public interest, and until any objections which may have been filed on the subject have been considered by the district collector. So two things: public interest and until any objection which may have been filed on the subject. If there is so district collector has to consider it, whether it is in a public interest or any objection is filed. So they are two independent things, maybe, or maybe both. Now, objections from the local bodies and from the following persons will be considered. This is also being mentioned.
And my lord is correct, page number 74, where the minutes adopted by the Deputy Commissioner, along with the village authorities. This aspect has been considered. Page number 74.
I think the order is perfect.
But only my lord, we can see page number 194, 95 only. But the village authority came forward fairly that we have considered all these
They will
aspects.
consider it. They will consider it. Whether it's, see, sitting here, we cannot decide what is in public interest. And public interest, yes, this is all very, it could be very subjective as well. So we'll consider when the public interest issue comes at all in future, we'll consider it. But for the time being, a timeline is given within which they should complete it. I think that is fair. No? Stay down. The appeal is arising out of Yes.
If Lordship, this is an appeal against the order, imperial order passed on the 31/10/2025 by the Lanit single bench, Your Lordship. What happened in the wake of the case here? The private respondent also is involved. Now here the core issue of the petitioner, the contention of the petitioner, appellant hearing is that he
Yes,
is the
that's fine, absolutely. Still, this issue is decided. The respondent numbers shall continue to be the in charge headmaster.
is
You
Lordship.
have asked for reinstatement. You have asked for reinstatement. So it says that we are not at this stage deciding on the reinstatement, but we direct, and there's a time frame within which to be held earliest, preferably within 2 months from the date of this order, strict supervision. So there's nothing wrong with the order.
Yes, Lordship, our grievance is Lordship here. What happened? The appellant here is he has cleared all the B.Ed and D.El.Ed and then as per the NCT norms, they should have requisite qualification should be appointed as a headmaster. In this in this case, what happened, Your Lordship? The person who has given an in charge for interim headmaster, he has not even he has not fulfilled the NCT norms. That is the main crack of the case and the argument of the appellant hearing, because there are 4 teachers. None of the teachers have been qualified. They are only HLC. They have only matriculate. But here in the appellant have completed his BSc. Also he also completed the DLED, which as per the Right to Children RTI Act, Your Lordship, he has qualified, academically qualified to be appointed as headmaster. But despite of the Lordship, he was allowed to continue as a interim in charge as a headmaster. That is the grievances, Your Lordship. Because we have been writing this the representation and other things, and we have all the qualification. It is there in on the record, Your Lordship. However, he was allowed to the private respondent who have not having a requisite qualification as per the norm.
Decide. Take down.
Paragraph, my lord, paragraph
Take down.
Lordship, at this stage, that only the notice will be issued to the private.
appellant
Please, His Lordship. Lordship, here I've made
Here has come. Here has come. Why? Have you served upon the respond number 6 and 7?
No, Your Lordship. I have to take necessary steps in the service.
They are
Lordship.
required to be served.
I beg your pardon, Lordship.
They are required to be served.
Yes, Your Lordship. But Your Lordship, however, during the proceedings before the
Sorry.
during pendency of the proceedings before the London single bench, they were not served with any notice with respect to respondent number 6 and 7. But I have made them as
No, respond number 6 and 7 appeared before the London single judge.
No, Your Lordship.
They did not appear.
It was in the opinion of the London single judge that the entire matter and controversy in the writ proceeding, Your Lordship, that it is matter related with the state to
Who
decide.
is 6 and 7?
6 and 7, Your Lordship, is the headmaster of the headmaster, and the 7 is the school funding committee.
What are the service rules with regard to correction of the date of birth?
Lordship, that has been reflected by the London single judge, Your Lordship. There is an SR and FR in the state, Your Lordship. But the admitted fact, Your Lordship, that correction of the date of birth has been sought after the writ appellant had already retired. Your
Retired.
Lordship, yes.
No, Your Lordship, the entire
Lordship,
matter.
kindly see, she retired in 31st August 2024, and she filed that application for correction of the date of birth only on 17/10/2024. And if Lordship kindly have page 54.
No, sorry, yes. You are saying something. Yes, please tell us.
Your Lordship, my main entire controversy before the London single bench, Your Lordship, was that my year of birth has been wrongly entered at first instance, and I filed for rectification. Now, Your Lordship, in accordance with the document which I have relied at first instance upon when I joined service, Your Lordship, it's at page 17.
No, you cannot see. You cannot
my-
at the fag end of your career, and that too after you retired, you cannot seek the rectification of your date of birth. There's a settled law on this.
Yes, Your Lordship. But Your Lordship, in accordance with the mandate of the Meghalaya pension rules, Your Lordship, my document should have been prepared and ought to have been prepared 2 years before my retirement. But that was not the case, Your Lordship. And a letter was served upon me, Your Lordship, which I have relied as Annexure 5, which is at page 86. I was directed to appear before the State Respondent Office,
Page.
86, Lordship. It is Annexure 5. For preparation of my pension papers and to appear before the office on the 3rd July 2025. Now, Your Lordship, in my
So you retired when?
Lordship, I was supposed to retire in the year 2024. Lordship, but in accordance with
You
my
made the papers, Mr. Counsel. When did you make these papers available to her? When you made these papers available to her?
If Lordship kindly have a page 54, Your Lordship. Lordship, kindly see the date of birth. That is 26/8/1966. And Lordship, kindly have
Now, when what is the earliest opportune moment when he came to know of his date of birth from the service record?
Lordship, she
Because
came
at
in
the
2019.
time of joining, there is a declaration, maybe a declaration.
Lordship,
But
kindly
then
have
what
a
is
page
what is the rule
57.
with regard to correction of the date of birth? What is the rule with regard to the date?
Lordship, within 3 years.
No, show us the rule.
Lordship, right now I don't have the rules, Your Lordship.
Produce the rules.
Lordship, I'll have the rules then. But if Lordship kindly have a page 54 for the moment.
No, we want to see the rules. This document will not be of much relevance. This is maybe the document which she filled up.
Lordship, yes. 54. And Lordship kindly have page
She
57.
filled up this document.
Lordship, yes. And Lordship kindly
It is
have
in her own handwriting.
a Lordship, yes. And Lordship kindly kindly see her
This is
signature
your
at
own
page
document.
57. Lordship kindly
Just
have
a minute,
a
just a
page
minute. Page
57.
54 is a document which you filled up in 2011.
Lordship, in accordance with the instructions so far regarding the documents which they have relied, Lordship, I just put the signature, and I have not filled
You are an
up
assistant
any-
teacher. How could you are an assistant teacher? You are not a
Yes,
literate
Lordship.
So
But
you will
Lordship,
not
in-
verify that whether you will not verify whether details are correct or not.
Your Lordship, before the proceedings before the single bench, I have raised allegation there has been tampering with one of my documents which I have relied, Your Lordship. Your Lordship, the document which has been
No,
produced,
show us any document after 1st August 2011 which has been filled up by you showing the correct date of birth. After 1st August 2011, show us any document wherefrom it would appear that you have entered a date of birth which is different from the date of birth which is mentioned in the when he or she was appointed. When she was appointed,
she was appointed since July.
87, Your Lordship. Dear 1987. Lordship kindly have a page 26 of the memo of appeal.
it's 26/8. Here also it is mentioned 26/8/1966. So 26/8/1966 is the date of birth.
Lordship,
That
yes.
you have disclosed when you joined the service. See, when you joined the service, that date of birth has to be filled up by you in hand.
Yes, Your Lordship.
That
Lordship,
that you mentioned as 26/8/1966.
Lordship, the document which I have relied is at page 16. Lordship, 17. This is was issued by the school. Back then in 1987, my date of birth, which I've relied as a document at first instance for my date and year
Her
of
date
birth.
of birth was 26 August 1967.
Yes, Your Lordship.
And that was appeared from the high school living certificate.
Yes, Your Lordship. Now, Your Lordship, may it please, before the...
So these school certificates mention your date of birth as 26th August.
Yes, Your Lordship. And the
These
years...
school certificates are valid certificates
Yes.
for the purpose of date of birth.
Yes, Your Lordship.
Then
Your Lordship, the controversy here is matter with respect to the year of birth, Your Lordship. There has been entry at
your school living certificate, what is mentioned here? 67?
67, Your Lordship, yes.
Then
Your Lordship, as per the retirement, my retirement, they say it's 66. That I was due retirement last year. Instead, if it's 67, I'm due retirement.
have you disclosed your matriculation, school living certificate?
Yes, Your Lordship.
Page?
I have even enclosed before the proceedings for the single bench as well, Lordship, which is at page 72.
Seventy-two. Yes. Our date of birth is 26/8/1967.
No, Your
Here it is
Lordship.
66.
Kindly have a page 53, Your Lordship.
No, 66, 67, yes, 67.
Kindly have, Your Lordship. This is the date. This is the date entered in the service record. So it is the conclusive proof, Your Lordship, that her date of birth is
No.
26/8/1966.
You see, one thing. If he has produced, if he has produced his school living certificate, which shows that his date of birth was 26 August 67, then the entry made by you has to be wrong.
No, Your Lordship.
Lordship,
She
I
has
have,
never produced that admit card at the date of birth, Your Lordship. That is the
No.
admit card.
When he applied for this, when he applied for the job, you asked for certain documents.
Lordship, yes.
What documents you asked for?
Lordship, Lordship, kindly have page 53.
You produce a file. We want to see the original file. You produce a file. Take down. The service record of
My Lords, on the last occasion, an instruction was placed before Your Lordship by the respondents appearing for respondent number 1 to 5, my Lord, on the query whether, my Lords, they are keen to extend the benefits of the scheme under, my Lord, ACP and MSP, my Lord. Now, from the perusal of this instructions, what they have produced, my Lord, few things have emerged, my Lord, although they have been taking this stand consistently from the very beginning, my Lord. Now, my Lord, if Your Lordship allows me, my Lord, to place before Your Lordship the scheme, the ACP and MSCP, in order to, my Lord, understand, my Lord, whether I'm actually eligible under this scheme, because there are two stages apparently now, what they're trying to project. Now, the stage which the state government is saying that from 2014 till today, my services was absorbed in 2014. So they want to basically say that 1993, when I was first recruited by following the due process of law in the MTDC, I was not a government employee, my lord. So if I am not a government employee from 1993 till date, my lord, so I am not entitled to the scheme.
Now you have been provided with this.
Yes, I have gone through, my lord, the instructions which they have produced.
All the documents are on record.
My lord, all the documents are on record.
Anything left out?
No, Lord, no. My Lord, the appeal, they have not filed any objection to the appeal, but they can plead from the record.
No objection is required. All that we require is to have the record before the single bench.
Yes, my Lord. Everything is on
That
record.
is there.
Everything is on record.
So you just do one thing.
Yes, my Lord.
You prepare an index.
My Lord.
Treating this as a paper book for the time being.
Yes, my Lord.
Because if it is the writ petition, shall be treated as a paper book.
Yes, my Lord.
For the appeal, and it prepare proper index.
Yes, my Lord.
And you also include this in your as a supplementary paper book.
Yes, my Lord.
What they have given.
Yes, my Lord.
And gradation list was given. This hand over this document.
Yes, this gradation list was also part of the main records before the learned single judge.
Well, so you also include this.
Of course, my Lord.
And you file your short notes of argument, both of you. Then we'll hear out the appeal.
Yes, my Lord. That can be done, my Lord. We can file it in a way of a written argument, my Lord, if your Lordship allows.
Written argument.
Yes, my Lord.
So both of you file a written argument and include this straight down.
My friend is going for the state pilot. The principal.
Okay, Lordship, we'll do it.
Very well, straight down.
Yes, my Lord.
The written submission, the written submission on behalf of the Call the list.
Item number 1.
One 061 days today. One 067 days, zero, madam.
Yes, Your Lordship, sir. They are retired employees and then they are very in advanced age, very senior citizen, and 17 of them have been deprived of their gratuity retirement benefits.
But they did not challenge the decision contemporaneously, madam. They waited for the Supreme Court judgment to come in respect of others who have, after taking VRS,
Yes,
there was one group of writ petitions
yes,
who, after obtaining the VRS, approached the court for gratuity.
yes.
That was not allowed. The matter went up to the Supreme Court. Supreme Court said gratuity is payable. You did not take VRS.
Me, sir, we did not take VRS.
You did not take VRS. So
Yes.
you retired from service.
Yes,
Now, you retired from service, you said that the gratuity was not paid to you.
yes. It was not paid. Only for 2 persons it was paid when we,
Out of 95, I think 2 were paid, if I'm not
no,
wrong.
95. 95 were already paid. Then again, we applied for 25 of us. Then later on,
You are for the state.
yes,
Lordship, yes, I'm for the state.
Why you should not pay the gratuity?
Lordship, this is by the Mekofet, Your Lordship.
Huh?
By the Mekofet, Your Lordship. That is the
No, why you not pay the gratuity? That's what I'm saying.
Lordship. This is to be done by the Meghalaya State.
If you have paid the gratuity for 95, and then for remaining 28, why you should not pay gratuity?
Lordship, these are the employees of the Federation, Your Lordship. These are not the employees of the state, Your Lordship. Lordship, if Lordship kindly, the area of parties in the miskis also is not proper. If Lordship kindly have page 2 of the miskis. Page 2 of the miskis. Lordship, I kindly see the areas of parties at page 2 versus State of Meghalaya represented by Mekofet. Mekofet is a federation, Your Lordship. Then Lordship, if Lordship kindly have a page 4 of the memo of appeal. Kindly have page 4 of the memo of appeal, Your Lordship.
Page 4. It's going to be this mistake, long description. You have to make the other as parties, madam. You have only made State of Meghalaya.
State of Meghalaya, RCS.
You have to give the cause title that was there in the main writ petition. You have only made State of Meghalaya. You have not made the Register of Cooperative, not the Managing Director, Meghalaya State Cooperative. You have not made them parties. In your miscase,
Yes.
you see the miscase, who are the parties? You have only stopped at Meghalaya, State of Meghalaya. Others have not been added.
State of Meghalaya represented by Secretary to the Government of Meghalaya.
No. You see your application for condonation of delay.
Condemnation of delay.
You have only made State of Meghalaya. What about the other respondents? You correct the cause title. Although you said others, but in the cause title you have only made State of Meghalaya. What about the other respondents? You have to correct it. Correct the cause title, serve them, and then we shall see to it. Okay, now.
Sir.
Leave is given to correct the cause title of
No, this is not fine. It's another case. You can address that. May I please your lordships? My lord, there is a delay of 141 days, my lord, in preferring in an intra-court appeal, my lord. May I pray, my lord?
You condone the delay.
My lord.
What one days? Now,
My lord, may I pray this, the memo of the main petition or the appeal, my lord, may it come out on the Tuesday, my lord. I have not read through the files, my lord.
you are not ready. Yes.
So, my lords, I'm appearing for 1, 2, 3, and 4. 5 is the union. They haven't been served, I suppose.
Five
in
is
the
Union
meantime-
of India.
Union of India.
In the meantime, we'll serve a copy to the union also, my lord.
No, you are representing 1, 2,
State
3,
1
4.
to 4.
DSJ, Mr. DSJ, you have a junior, so she can accept.
In the course of the day, we'll serve, my lord, through.
This is very good. The respond numbers 1 to 4. So this is 30. Yes.
Item number 3, my lord, I am here for the petition. My lord, this is a matter from the CFL Tribunal, Guwahati. So it is a matter, my lord, where the petitioner is a postal assistant serving in GPO Shillong. A discipline charge sheet was issued on 19/5/2017, and inquiry was conducted. Inquiry was conducted and penalty was imposed by the order dated 22/6/2018. The petitioner preferred an appeal, and upon consideration of the appeal, the appellate authority has observed that there is a procedural lapses. The inquiry was not conducted as per the Rule 14 of the CPSCA rule. This order is at page 126.
Yes. The appellate authority has specifically
Observation
directed
part,
de novo proceeding.
De novo proceeding from the stage referred, that is the charge sheet. Because the matter is, my lord, it is a well settled portion of law that if there is a procedural lapse, then, my lord, the matter to be remanded back from the stage where defect was crept up. So,
Yes.
observation which may kindly tribunal did not observation or did not get the weightage on the observation. On page 126, observation part, observation on the appeal provision of the Rule 14 CCA rules. Rule 14 CCA is a procedural aspect, and thus it has procedural lapses. So, after the observation, the appellate authority held that
No, it
from
will
the
start
issue
from
of the
the
charge sheet.
no no
The charge sheet was
it will start from the issuance of a fresh charge sheet.
Yes.
Yes.
They are saying the same charge sheet should be taken up, my lord. That is their case.
No, you see, initiation of
Not-
initiation of a departmental proceeding commences with the issuance of a charge sheet. So here, what happened? The authority
Issuance
who has issued the charge sheet. What was the procedural defect?
yes, my lord.
What was the procedural defect?
Procedural defect, my lord, that is I am coming to the, my lord, page 136.
No, please tell us what was the procedural defect.
The order doesn't say anything, my lord.
What is the de novo proceeding? Possibly, that is de novo proceeding, and my lord, this de novo proceeding should be
Just
unless
we wanted
the
to know
first
from
one
which the inquiry has gone.
36 one.
Yes, so it should be because of the
From page 121, it appears as it was ex parte. My lord.
no, it should start. It should start from the stage of the issuance of the charge sheet, not a fresh charge sheet. It cannot be a fresh charge sheet because if you read paragraph 6, effect of de novo proceeding. When on appeal, the appellate authority sets aside the punishment orders and remits the case for de novo trial, the original proceeding contained in the charge sheet are to be deemed to have been quashed unless the stages from which the retrial should be conducted is specified in the order. Now, if you read this paragraph with paragraph 7 of the judgment, where this Nand Kumar Verma's case was referred,
Yes.
therefore, when a completed inquiry proceeding is set aside by a competent forum on a technical or on ground of procedural infirmity, fresh proceeding on the same charges is permissible. And what will be the stage? It will stage from the issuance of the charge sheet, because what he is challenging is that after the charge sheet was issued, there has been procedural lapses. So there cannot be any fresh charge sheet. If there are any other charges, you may issue a fresh. That is my interpretation. But it has to be start from the stage of after the issuance of the charge sheet, meaning thereby, if there is show cause, then there is reply to the show cause, and then the charge sheet is issued. On the basis of the charge frame, article of charges supplied to them, they will find the statement of defense.
Now, my lord, the only thing, Lordship kindly sees the appellate order, my lord, page 126.
126.
Yes, sir.
126. Just a minute. The disciplinary case was initiated and the following punishment was awarded. Observation that the case has not been dealt with properly under authority rules. Case de novo proceeding from the issue of charge sheet. Yes. So it was from the issue of the charge sheet. So charge sheet is not quashed. No fresh charge from the issue of the charge sheet. That is what exactly in conformity with rule 3.
136.
6 paragraph 3. That is your rule 27. So from the issue of charge sheet.
My lord, read with, I'll read once again, my lord, rule 3, my lord. But it says, my lord, effect of de novo proceedings. When on appeal, the appellate authority sets aside the punishment orders and remit the case for de novo trial, the original proceedings containing the charge sheet are to be deemed to be quashed, unless the stage from which the retrial should be conducted is specified in the order.
So here, it said de novo proceeding from the issue of charge sheet.
From the issue of charge sheet.
From the issue of charge sheet, from the stage when the charge sheet was issued. It doesn't call for a fresh charge sheet. Because procedural lapses were noticed.
From the issue of charge sheet, my lord, that is how the department it appears, my lord, interpreted that, my lord.
Oh, what was
Do you know trial from the issue of charge sheet, my lord?
the issue has been interpretation of the possibility of authority on the appeal of the appellate. This is the appellate authority, correct?
Yes,
The 13th June,
Yes, my lord. 13 July 2020.
13th July. The relevant provisions in place 27. Constitution in case of appeals, in case of appeals are imposing penalties, limiting the case to the authority which imposed or enhanced a penalty or to any other authority which such election is for initially. In accordance with circumstances for limited the matter de novo on the stage of charge sheet. The decision of the mean of the inquiries will be conducted from the stage of issuing the charge sheet as if it is fresh charge sheet from the stage of queue of charge sheet.
If the word was stage of charge sheet, my lord, the meaning would have been different, my lord, in my humble submission, my lord. From the issue of charge sheet.
Stage of issuance of charge sheet means the charge sheet has not been held to be bad. We have to give a meaning to it. From the defect was noted from not in the charge sheet. Defect was noticed after the proceeding was commenced. It may be the inquiry officer has not conducted properly. There may be procedural lapses.
Well,
So this fresh, it does not contemplate that you issue a fresh charge sheet. In that case, what you have to withdraw the entire departmental proceedings, and you make a fresh charge. Even at this stage, from the date of issuance of charge sheet, you may issue a supplemental charge sheet also if you find that there are other materials.
my lord, in fact, if we take a lordship to the two charge sheets, my lord, of course, a few things have been added in the supplementary charge sheet.
No, it is a fresh charge, it is a fresh day, and charges are totally different.
Date, of course, is it?
No. Supplementary charge sheet could you can issue that. There is no bar in law that you cannot issue multiple charge sheets.
Yes, sir.
But one charge sheet, you can issue a second charge sheet also if you find that something also has come. On subsequent revelation of fact, you can also issue a second charge sheet.
Yes, my lord. But the difficulty, my lord, the order has been implemented. There was a recovery of 20,000 per month for 13 years from his salary, my lord. He defaulted a substantial amount of money, my lord. Some recovery was already done. 20,000 for 30 years, my lord. That is the recovery.
No, but after this order of 13th of July 2020. Then
prior to that, the order was implemented, my lord. 1,20,000.
When the penalty goes,
yes, ma'am.
in that case, you have to refund the money. You have to refund the money.
But now we will come back to situation, my lord. He may not have 13 years of service to recover the money also, my lord. If we start now.
No, that's a different issue.
Yes, my lord.
That's a different issue. If there is a defect in the procedure,
Yes,
then
ma'am.
that has to be cured. So once this director said that observation on the appeal of the appellant are that the case has not been dealt with properly under the Regulation 14. So what is the Rule 14 of CCS rules? Give us a Rule 14 of CCS rules.
Procedural aspect, how the inquiry to be conducted.
So if it is found that the inquiry was not properly conducted, then
Yes, ma'am.
de novo trial would mean from the date of issuance of the charge sheet.
Yes.
It's not that this order has to be read in the context it was passed. Issuance of the charge, it does not contemplate then you have to say the entire charge sheet, earlier charge sheet is withdrawn. If the earlier charge is withdrawn, then all recovery you made has to be paid back to him. And if
And that is what he's claiming, madam.
yes, that's a natural consequence. And if you say that yes, for the purpose of departmental proceeding, you are required to be kept under suspension, then you are required to pay him the subsistence allowance.
Yes, my lord.
So at this stage, when this order was done, so this entire recovery, the penalty goes. So you have to refund the amount.
My lord.
You have to refund the amount because it is as good as he is innocent.
Yes.
And then if you decide to put him in suspension, then you need to pay him the subsistence allowance. So the penalty goes. So what you have recovered, it has to be repaid.
It has to be repaid.
And 14 says, departmental procedure prosecution types of cases to be classified. What is this? Provisions of Rule 14. Provisions of Rule 14 was not followed.
Rule 14 is primarily how the inquiry officer is to appointed, my lord.
14, no, it's
CCSCC rules.
huh? You find it.
The procedure.
Yes.
14, where do you find it? I don't find it. 14. Wrong page. Page 40. Sorry. Yes, 14. Imposition. Now, 14 is procedure for imposing major penalties.
Yes.
So, what stage it is? It is the stage when penalty was imposed, procedure was not followed.
But I follow, my lord. But we faced TPS, my lord, difficulty only because the word used is.
No, this order has to be read what he says.
Yes, ma'am.
He found fault in the procedure adopted for imposing penalties.
Yes.
Hence, he said, de novo proceeding from the issue of charge sheet. That means he has gone even far back. So it has to be a fresh inquiry now.
That is what we have done, my lord.
You should have challenged this order.
But
See,
the difficulty is our own officer, my lord. It is our own officer.
Rule 14, he has in fact gone beyond.
Yes, sir.
He should have said that the Rule 14 has to be complied with.
Contextually, but we face difficulty only because of the wording of the appellate order.
No, but it has to be read context. What is issuance of charge sheet means he found also defect in the inquiry leading to punishment. So his representation.
Yes.
So it has to be from the stage when the charge sheet was issued. If you find any other thing, you do a supplement, that's up to you. We are not entering into that. We are only merely interpreting this. We are not saying anything more than that.
But what I would pray, my lord, because this was issued in 2021, my lord, the fresh memorandum of charge. And now I'll take instruction on whether the proceeding has proceeded any further or it is in the nascent stage, my lord. Or Mr. Nath can enlighten on that, whether what happened to the
What
second.
the judgment, the appellate authority specifically writing de novo proceeding, which would necessarily mean the earlier proceeding of portion set aside, the way therefore is dismissed. In the way what he challenged.
In the way he challenged the memorandum, second memorandum of charge, my lord.
See, second
Yes, 44, my lord.
memorandum can be independently issued. What he said,
Yes.
what he said was nothing to do with this. Nothing to do with, so far as this proceeding is concerned, this proceeding, he said that from the stage of issuance of the charge sheet. But this does not debar you in our reading from issuing a further charge sheet. You can
It
always
can be
make
a supplementary or independent charge sheet.
yes, that is there.
My lord.
But that order only means that it has to commence from the stage when the charge sheet was issued.
My lord, kindly give me 2 or 3 days time.
Yes,
I'll
very
just talk to
well.
the department.
We have heard the learned counsel for the parties.